Okay, very good afternoon, ladies and gentlemen joining us this very beautiful afternoon. I bring you very warm greetings from Arusha, Tanzania at the East Africa Law Society House. Welcome to yet another segment of our webinar session for the month of September. Today, ladies and gentlemen, we discuss a very interesting subject that has captivated the whole region and taken us by storm, and that is the emerging trends in billing. And this is in light of a judgment that was issued by the Supreme Court of Kenya in Kenya Airports Authority versus Otieno, Ragot and Company Advocates, petition number 11 of 2023. My name is Gabriel Achaye, and on behalf of the Secretariat, we would like to welcome you to this session and to wish you a very lovely webinar. Our session this afternoon will be moderated by Mr. Alan Musasire. Mr. Alan Musasire is a partner, managing partner at Katembeko and Company Advocates. It's one of the oldest law firms in Uganda and has held quite a very good reputation across across the country in Uganda. Mr. Musasire holds a master's degree in public health from Mbarara University of Science and Technology. He has a postgraduate diploma in legal practice. He holds a Bachelor of Laws degree with honors from Makerere University in Kampala, and he serves as council member at the Uganda Law Society. Mr. Musasire, this afternoon we are profoundly honored and exceedingly humbled to host you for our webinar session. But before you take us away, ladies and gentlemen, I would like to interest you in the second edition, the 2024 edition of the Construction Law Conference and FIDIC Contracts Management, which is happening on the 25th to the 27th of September in Kigali, Rwanda. Please book your slot today. It's going to be the biggest convening of construction law enthusiasts and people who are interested in this sector and major players within the sector. So to book your slot, visit our website and register to confirm attendance. Otherwise, I will now hand over to Alan to start off the discussions. Please feel at home. Housekeeping rules will be given by the moderator. Over to you, Alan.
Thank you very much, Gabriel, for starting us off. As introduced, my name is Alan Musasile. I am welcoming you all to this webinar series of the East African Law Society, and I am humbled to be the one hosting you. Without wasting time, allow me welcome our panelists who are with us, and I'll briefly introduce them and ask them to say hello before we get started. The first panelist we have is Martin Munyu, who is a partner with the Dispute Resolution Practice Group, and he has a vast experience in corporate commercial disputes, arbitrations, particularly in construction, insurance, and contractual disputes, as well as employment disputes. He is a fellow of the Chartered Institute of Arbitrators with a keen interest in alternative dispute resolution. Martin has been involved in a wide range of disputes and various sectors, including banking and financial services, construction and engineering, employment, insurance, and in commercial arbitration. Martin also has experience in electoral disputes and has successfully represented the country's Independent Electoral and Boundaries Commission in various election petitions. His portfolio of clients includes several sectors: banking and financial services, telecommunications, government, and state corporations. Martin, you're welcome. Can you please say hello, people?
Thank you. Good afternoon, fellow colleagues from the East African region. It's a pleasure to be here.
Thank you very much. Our second panelist for tonight or this evening will be my old friend, Mr. Colin Gatete, who is a practicing advocate and managing partner at Colin & Colin, based in Rwanda, in Kigali. He holds a master's degree in international commercial and arbitration law from Stockholm University in Sweden, and has a bachelor's degree in law from the Catholic University of Eastern Africa in Nairobi, Kenya. He has successfully taken advanced trainings in complex commercial transactions from ALSF Academy, and also holds a certificate in international criminal law from the Nuremberg Principles Academy. Before joining the firm that is at Colin was previously at the Rukangira Law Chambers, the Africa Legal Network, also worked at the National Public Prosecution and Bank of Kigali. That's a whole wide experience. He has expertise and experience in commercial transactions, employment, legal advisory and consultancy, intellectual property law, taxation, and dispute resolution. Colin is also a lecturer at the School of Law, University of Kigali. Colin, kindly say hello to our participants and attendees tonight.
Thank you very much for having me here, and I'm happy to be joining my able panelists to share experiences around our practice, especially in terms of the emerging trends in billing. I'm happy to be here. Thank you very much.
Okay, you're welcome, Colin. Our next panelist tonight is from Uganda, and is by the names of Laston Gulume, who is a practice director and the head dispute resolution department, that is ADR and litigation at LP Advocates. He has a demonstrable record of efficient and effective client advisory in the areas of arbitration, litigation, tax, trade and investment law, corporate and commercial law practice, regional integration, intellectual property, public interest litigation, as well as immigration law. Laston is a registered insolvency practitioner and a commissioner for oaths. Counsel, please say hello to our attendees and participants.
Yes, Alan, thank you for the kind introduction. It's, of course, a pleasure to be here. Thank you to ELS for organizing this. And when we are talking about money for lawyers, it's a very good thing to discuss in an afternoon. So, you know, as soon as we get almost the end of the year, we know where the money should be coming from. So it's a pleasure to be here to share some insights. And thank you so much, Alan, for the kind introduction. Thank you.
Okay, welcome, Laston. And finally, our last presenter for this evening is Senior Wali. The second name, he might sue me if I don't pronounce it well, but I will try. Shezada. I hope I got it right. Wali Amil, you're welcome. But he's a managing partner at Reeve and Company, resident in Dar es Salaam. In his 13 years of practice in Tanzania and Zanzibar, he is a dynamic legal professional specializing in dispute resolution, corporate and insolvency law, mining and energy law, banking and financial law, as well as telecommunications law. He has leadership at the helm of the dispute resolution department and is nothing short of exemplary, with a keen eye for detail and steadfast commitment to achieving equitable outcomes. Apart from his role as the managing partner, Wali embodies a multifaceted commitment to legal excellence and community engagement. He actively serves as the chairman of the Conscious for Humanity, that is Utu Kwanza, an NGO he founded to improve the quality of lives of prisoners, their families, and prison officers in Tanzania. Wali is an accredited mediator and serves on the board of the Shia Imami Ismaili Muslims community. He served as the vice president of the Zanzibar Law Society and has served 2 terms as the chairperson on the Young Lawyers Professional Development Committee at the Tanganyika Law Society. Currently, he serves as the vice chairperson of the Regional Trade and Integration Committee of the East African Law Society and a member of the Advocates Welfare, Remuneration and Awards Committee of the Tanganyika Law Society. Welcome with me, my senior colleague, Wali.
Thank you very much, Alan. It's a pleasure being here today and being among all the esteemed colleagues. I just wanted to make one slight correction because the TLS has a new governing council. There are some changes in my role at the TLS. So I'm no longer in the Advocates Remuneration and Welfare Committee. I'm now a member in the Continuous Legal Education Committee at the Tanganyika Law Society. But otherwise, I'm very happy to be here and looking to learn from everyone and share some of my own insights. Thank you.
Wally, allow me congratulate you upon that your new role. Congratulations.
Thank you.
Otherwise, you're welcome.
Thank you.
Our dear participants, tonight or this evening, we are going to be discussing the most important decision that the Supreme Court has handed down. That is the Kenya Airports Authority versus Otieno, Ragot and Company Advocates, petition number 011 of 2023, which was delivered earlier this year. This is a case you realize that started in 2009. For some of us who have been litigating, you realize that the advocate comes to get the fruits of his labor after almost 15 years. That is when a lawyer thinks of getting what is due to them, even after it has been awarded by lower courts and going through all this litigation. Without wasting time, I will call upon our first panelist from Kenya, Martin Munyu. Give us an insight. What exactly did the Supreme Court say? What was the gist of this ruling, such that our colleagues from the other East African countries and the attendees can benefit from this? Thank you very much. Welcome, Martin. Martin, your screen is very visible. You can unmute if you're speaking.
Okay, thank you. I hope my screen is let me reshare again because my voice was lost there for some time. Yes, I think now we can start. I believe a number of us have interacted with this decision. It was delivered on the 3rd of August, and two controversies, amongst many others, immediately arose, and it makes significant points for discussion. The first controversy was on the jurisdiction of the Supreme Court, and one of the strongest controversies that came up after this decision was, has the Supreme Court now gotten into arena of municipal courts that is now discussing issues of bidding and remuneration for lawyers, because it was felt that this should never have been an issue that should have gone to the Supreme Court. And so I thought it is good for us to understand the jurisdiction of the Supreme Court of Kenya and the kind of matters that would go there and how this matter ended up landing there. The other controversy that came about was the implication of this whole judgment. Remember, at the end of the judgment, and you will see in the decision and the issues that were discussed, the judgment has put in certain limitations on the kind of fees that lawyers can recover at the end of the day, and kind of given interpretation that was hazy, where the subject value is not ascertained or cannot easily be defined. So some lawyers have felt that it's kind of an affront to their pockets, the decision is limiting how much they can recover, is stifling how much lawyers can recover, and in a way giving teeth to clients. So these are some of the discussions that we want to see. And probably in different jurisdictions, there could be different approaches, but it's still causing ripples in that regard. So starting with the, my small engagement as a way of introduction so that we can have discussions would be the question of the jurisdiction, understanding what caused us to go to the Supreme Court, the issues that were before the Supreme Court, the decision itself, and some of the implications, just in a highlight. So Kenya's jurisdiction for the Supreme Court is found on Article 163 4 of our Constitution. And you'd remember by 2010, that is when we got the Supreme Court. I think Uganda had the Supreme Court before us, and maybe some other jurisdictions, but Kenya's Supreme Court came about after the 2010 Constitution. And the jurisdiction is that appeals shall lie there, matters that involve interpretation of the Constitution. That is a direct appeal to the Supreme Court. So whenever there is a question that touches on the Constitution, that you can appeal on all levels, all the way up to the apex court. But where there are other questions that now form what are called matters of general public importance, the court can give leave. That is the Court of Appeal, where would be the last stage before the Supreme Court. It can give leave and certify that such a matter is of general public importance and allow you to go to the Supreme Court. This is what happened in this particular case. KAA filed a motion after the Court of Appeal made a finding, and we will discuss the facts, and asked that it be granted leave by way of certification to raise these matters of general public importance on questions of whether the fees would stifle the possibility of ordinary Kenyans affording fees and approaching the court. And the Court of Appeal found that the issues that were involved were beyond KAA itself. They were beyond the parties themselves, and they transcended to the general public importance and gave leave. The lawyers found that that was not warranted. An appeal and a review was done at the Supreme Court challenging that leave, and it was argued the Supreme Court still considered that matters of general public importance arose, and so this matter then found its way to the Supreme Court. So one of the issues that now has been is that are matters of bidding really matters of general public importance? And you could find this ruling on the review. Probably if you're able to get to Kenya law, you would be able to find it on the website. The justifications why this is a matter of general public importance, and why we were able to jacket ourselves within this subsection 2 of Article 163, that a certification that the matter was of general public importance, warranting determination by the Supreme Court. So the factual background in a brief, during the construction of the Kisumu International Airport, and some of us may have landed there, a number of residents there, 54 of them, filed a claim against KAA seeking compensation. Now, the framing of this suit is what now caused a lot of confusion all the way from 2009 up to the time the Supreme Court has given its decision. And I would like us to see the framing of the suit was that each plaintiff claims an average of 258 million for loss of land, development, inconveniences, current and future loss of profits to be earned from each plaintiff's parcel, which aggregates Kenya shillings 13.9 billion. And then they say each plaintiff will tender evidence for loss of land, loss of profits, damage, and inconvenience at the hearing. Remember, the hearing never reached because a preliminary objection was successfully argued that these were matters that should have been dealt with by way of arbitration. And so the hearing never took place. In the circumstances, this claim was never proven as to whether there was really a claim for this 13 billion. However, as we would normally do, party and party costs was assessed based on that value of 13 point something billion. And a sum of 151 million was assessed. Now, based on that assessed party and party, Kenya's remuneration order would then say the advocate-client costs would be P&P, party and party, increased by a half. So that then it would be 151 million, increased by a half, another 75. So there would be a claim of around 227 million. And this is what was filed by the advocates as their legal fees, based on the remuneration order, which then said party and party increased by a half. And I believe maybe some of our jurisdictions have such provisions, which provides that arithmetic argument. So in the whole of this discussion, remember the description of the claim, that it is an average of 258 million for development, loss, and then aggregate. So look at that wording, average, aggregate, to be proved or to be evidence to be tendered at the hearing. That is what was before the court. So the taxing master, which in Kenya would be a deputy registrar, applying her discretion, determined that the advocate-client costs be assessed at Kenya shillings 5 million and refused to operate on the basis of party and party increased by a half. And the argument was that there was exercise of discretion in assessing these costs, and that these costs should be independent of the party and party costs. Now, then she found that that sum of 13 billion could not be relied upon because there was no valuation report, there was no documentation on these parcels of land, there was no hearing where this value was actually proven. The process in Kenya is that once you get that assessment by a deputy registrar, you can file a reference or a challenge to the High Court before a judge. This is what was done. A challenge was filed before the judge, and the judge upheld that and decided that the taxing master was correct. The lawyers then filed an appeal to the Court of Appeal against the decision of the judge, and the Court of Appeal substituted that assessment and took it back to arithmetic argument, where they then decided that there should be an assessment of party and party increased by a half. So what had been assessed at 190, at 5 million was taken now up to 196 million. And this is what caused this case to land at the Supreme Court. However, it is instrumental to note that the Court of Appeal did not wholly agree with that evaluation. It was a majority decision. Two judges held that the argument or the computation should be a mere arithmetic exercise, party and party increased by a half. One judge, in a dissenting judgment, considered that there should be an exercise of discretion, and that in an ascertainable circumstance as this case, you cannot apply that arithmetic exercise. So when this matter then landed at the Supreme Court, there were 4 issues that we asked the Supreme Court to decide. And probably this could be significant for us in this discussion. The first one was what was the proper interpretation of the phrase, whether the phrase fees expressed in A increased by 1/2 takes away the discretion of the taxing master. What does that mean by increase by a half? Does that mean that the taxing master would just take a calculator and calculate, especially in a case like this? The second one was whether the power and discretion of the taxing master is fettered when the remuneration order says fees prescribed by A increased by 1/2. Does that mean that the taxing master then becomes just a machine? Then the other question then we asked is how should the courts interpret subject value, where in a description such as this, the language used is aggregate, to be proved, future losses. How should the subject value be ascertained? In our argument, we thought the figures there were fictitious, they were unsubstantiated, they were unascertainable from the pleadings, and so could not be relied upon without valuation reports being tendered. The last question we asked the court to decide is whether where there is a certificate of taxation, and I'm sure in some jurisdictions, the taxing masters would issue a certificate of taxation of party and party costs. So the question was, is that binding per se on the taxing master when presented with an advocate client, so that then they have no way of looking back at how was the costs arrived at? So upon argument, and you will see that in the lengthy judgment, not lengthy, actually, it's just 30-something pages, 39 pages, you will see the arguments that arose at the Supreme Court. 4 main determinations come out of this. And from the first one here is that on the question of ascertaining the value of the subject matter, how do we ascertain the value of the subject matter? I would refer you to paragraph 59 of the Supreme Court decision, is that the claim in a suit which was struck out at preliminary stage, it does not render that claim or amount pleaded to be the value of the subject matter. If the claim, like in this one, where you are saying evidence to be tendered at the hearing, and then the hearing never appears, never happens, you cannot then say that that hearing has happened. However, I must draw a distinction. If it was, say, a claim involving a debt, and in today's pleadings, we usually produce evidence even as we submit our papers. In 2009, when this case arose, this civil procedure had not been amended, so there was no evidence produced at the pleading level. But assuming it was a pleading now, and there are bank statements that have been tendered, then even if the case is struck out, one can then say that the value could be ascertained. But in our case, the value could not be ascertained or determined. Therefore, applying such a sum would be erroneous, as has happened before the Court of Appeal. The next one was on the question of discretion, whether that discretion is fettered by the arithmetic formula in the advocate's remuneration order. If you look at paragraph 66 of the judgment, you will see these arguments there. And the Supreme Court found that that discretion is not fettered. In fact, there is a provision in the remuneration order, which is a subsidiary legislation of the Advocates Act, which provides that the taxing officer may allow all such costs, charges, and expenses as shall appear to him to have been necessary. That language gives discretion, where it says, as shall appear to him to have been necessary or proper for the attainment of justice. That means that the remuneration order cannot oust that jurisdiction that is founded in the Act itself, where the formula for party and party increased by a half does not oust that discretion of the taxing officer. And that is what the Supreme Court is saying, that the taxing officer should still look back and see what is the value of this case. What is the real issue, not just the figure that is pleaded. The other bit in terms of the determination is on the assessed party and party costs. This party and party costs, by way of the certificate that the taxing officer issues, should not be applied what the Supreme Court in paragraph 70 says, hook, line, and sinker. In actual fact, the Court of Appeal stated, and this was what was quite a challenge for us at the Court of Appeal, that there should be just an arithmetic formula, that once there is this party and party assessment, all that should happen is that one should just do a calculation. Now that has now been overturned by the Supreme Court, where the Supreme Court says that that should not be applied without consideration. Where the party and party costs are disputed, then the taxing officer should subject the disputed items to evaluation and judicial determination according to the circumstances of each case. So that then means that it shouldn't be blinded by just that certificate that is obtained. And sometimes there could be collusion. Sometimes there could be collusion where a lawyer could inflate a figure, a fictitious claim, obtain party and party cost assessed without the intention of even recovering this from the clients, but with the intention of using that certificate to recover fees from the client. This is what the Supreme Court is saying. Apply your mind to it and assess what is the actual amount. So what are the factors that should be considered in making that assessment? This can be found in paragraph 76, where the court is saying, look at the work done by the advocate. Now, work done by the advocate sometimes could be looked at in terms of the pleadings, the volume of pleadings done, the time expended, the industry expended, the amount of research that could have been expended. This can be clearly seen from the pleadings and from the exchange with the advocate and the client. Sometimes there could have been opinion meetings and such things that could have been undertaken. They can be ascertained, even though not very scientifically. Also, the relevance where the subject matter is considered. It could be that the subject matter involves a debt. Probably that may not necessarily be an outrageous or something that has not been done before. Probably it could be a new area of law. It could be a subject matter that has not been developed, where you may need to look for external knowledge and other references. There should also be a review of prevailing economic conditions. In our current situation, this judgment was issued against a public body. And there are other factors within our constitution that talk about use of public resources, economic conditions. I don't know, probably if the economy is doing well, maybe one may not query so much about a few variances in the amount, but prevailing economic conditions, the Supreme Court felt this should be a factor. But there is a respite for the lawyers, where the Supreme Court is saying advocates should be well motivated. So the fees should provide adequate motivation. It should not be what one would call peanuts. It's also in the public interest that even if they are to be well motivated, it should be kept to a reasonable level, so that in our case, it was KAA. Probably this is a big corporation, but assuming it was an individual, probably who only had that particular asset, then justice could be put beyond the reach of such litigants. And that is the balance that the Supreme Court looked. So that I maybe allow other people to jump into it, I will just dash into this. What are the implications after this judgment? What are the implications? And one of them is the whole question of access to justice. And the court is saying the right to access to justice is being enhanced by this judgment, so that one should not feel that I am curtailed because lawyers are charging fees that are unreached or beyond the scope. And so that has been emphasized, which is one great tenet of a constitution, at least in Kenya. Public policy ramifications, there are also these ramifications. In our context, the fees in this case that had been assessed by the Court of Appeal based on the earlier assessment are coming from public coffers. So there is that whole question of protection of public coffers. Then the interpretation of subject value and taxing master's discretion. That has come out quite clearly, which now removes the whole thing of the arithmetic mechanical review of costs and brings in the whole question of discretion. Remember, this discretion could work in favor at times where the taxing master is given discretion, not just to reduce the cost, but also to increase based on the industry, work done, and the subject matter itself. The last one is on the deterrence. It could act as a deterrence against advocates who file exaggerated bills to the detriment of unsuspecting clients. You can consider in this case, the bill was for 200 million. It is taxed at 5 million. It can cause quite some ripples in somebody's business. It can actually cause somebody to close down because of that exaggeration sometimes in the bills based on some of the factors that we have argued. So in a way, the judgment has huge ramifications. In Kenya, it becomes a law by way of precedent, which must be referred to by all the courts. And so it has these significant ramifications for all the courts below. And we hope to see quite some discussions as other courts apply this judgment. I think I'll stop here so that we can also allow other discussions.
Wow, 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 wow. Thank you very much, my senior colleague Martin. I'll appreciate you for the fact that you have given us an insight into what we are here to discuss tonight. And I would like my colleagues to chip in later, but before they chip in, I am wondering, yes, the Supreme Court has intervened, allowed that application. Had that application been allowed, would it have been different? I'm sure would it have been here, and the Court of Appeal decision would be standing. And then the other is, has the law been amended as we know it in Kenya? Do you now believe that the taxing masters authority has been fettered with? Do you think this judgment actually is going to affect moving forward how taxing masters are going to be handling the bills in your jurisdiction? But also, do you think this decision largely was because the funds that were going to be paid out were coming from the public coffers? And then lastly, you mentioned that this is a deterrence to the advocates who have been filing huge bills. Do we not see this as something that is going to demotivate the lawyers? Because the act was very clear on what to be done and what schedules to be followed, but now the Supreme Court has guided otherwise. Kindly take those away, and then we shall be going to our next panelist, that is our senior colleague Wali, who will be giving us insights from his side of practice in Tanzania. Thank you very much.
Yeah, thank you. Thank you very much, Alan. Yeah, you are right. If the certification of the matters of general public importance was reviewed by the Supreme Court, we would have ended there, and the Court of Appeal decision would be now what is carrying the day. But remember, in this case, there has been quite a lot of resilience from both sides, both the client and the advocate. So when that review was given, the advocate raised it before the Supreme Court by when the certificate was given, the advocate raised it at the Supreme Court, challenging it that it should not have been given, and it was disallowed. Even when the arguments arose, you will see in a part of the judgment, the judges are saying this issue was already dealt with, you can't go back to it. So, but if they had gone back to it, then we would never have been here. Whether the law has been amended, no. What the Supreme Court has done is to do an interpretation. In our Advocates Act, it provides for the remuneration order in the subsidiary legislation that is there. And Section 16 of the Advocates Remuneration Order, which was quoted in the judgment, is already there, which gives the discretion. So what they are doing by way of this judgment is to give some teeth to the taxing masters. Look at that section, use your discretion. Do not just be blindly applying an arithmetic formula. Whether this was because of public coffers, I don't think so. In fact, some of the judgments that have been referred to in this judgment by the Supreme Court have affected other people, not just public institutions. So one would argue that probably if the amount was not a large amount of money, maybe it would not have attracted this attention, but it is not on account of public coffers. In fact, when they talk about prevailing economic circumstances, maybe the person who may be affected by these economic circumstances may not be government institutions, maybe an ordinary, what we call an ordinary mwananchi. So I'm not sure that this was the major influence or was an influence at all. The demotivation aspect, they're both coins. In a way, and I've said that's one controversy that has arisen, that in a way this judgment then would then curtail how much lawyers can get. But what the court is saying, look at the work done. If you're able to determine that this is what you have done, then we should be satisfied with what is done. Remember, we would also be on the other side of the coin, and this judgment can cut both ways. When you are trying to get some additional or the best value for the work, this judgment would cut both sides. But I don't see it as a demotivation when applied, because it hasn't removed the application of party and party increased by a half, where the value is ascertainable. I think the issue is where it is a vague value. Let's say it's a judicial review application, or it's a constitutional application, or it is something like an election petition, for instance. The value is not definitive. So in those circumstances, that is where the whole question of discretion is being called upon.
Okay, thank you very much, Martin Munyu, for your very insightful comments. And I am sure now all participants are abreast with what we're here for. That is the decision that is shaking the practice waves in Kenya. And as the East African Law Society, we are worried, not as worried in worried, but we are saying, how is this going to influence jurisprudence? Because we are well aware that all our judges and practitioners borrow usually from the same leaf, and this being Kenya. Of course, I say that respectfully, but right now, allow me invite our second panelist, Kansowali, to give us the insights on the remuneration of advocates in Tanzania, And what are the emerging trends in Tanzania? What best practices do you have? And then the ethical considerations that the advocates have to undertake while being the clients. Thank you very much. Wally, you're welcome.
Thank you very much. So, first of all, it was very interesting to follow the judgment of the Supreme Court. In Tanzania, we have what we call the Advocates Remuneration Order, 2015, that governs the remuneration of advocates in Tanzania. I haven't come across a similar provision like the one in Kenya, where there is an arithmetic, the way they calculate their remuneration. For us in Tanzania, Section 41 has very clearly specified on what schedules to follow on contentious matters, and that is the 10th, 11th, and the 12th schedule, where you can find different rates when it comes to contentious proceedings. However, the trend is somehow similar in our law as well, in the event that the taxing officer has a discretion to basically, under Section 12, make certain decisions, but also a taxing officer may give over and above what was agreed on the remuneration agreement, if the taxing officer is satisfied that perhaps there was the matter was more complex, or there was more work done by the advocate. So there is a discretion of the taxing officer, which is being taken into consideration when it comes to the law in Tanzania. I will just then start. Currently in Tanzania, we obviously are guided by the Advocates Remuneration Order, where it is important to have a remuneration agreement between the advocate and the client. So these are guided by law. However, at the moment, the trends in Tanzania when it comes to billings are most advocates are billing on fixed rates. We are following the Advocates Remuneration Order. However, it is mostly used as a guiding principle, because sometimes it is more to do with negotiations with the clients. Hence, we do sometimes find ourselves in a very tricky position, where sometimes we're either billing below what we would want to, or sometimes above what is actually guided as per the Advocates Remuneration Order. So it's really not fixed. Most of us are using it as a negotiation technique to guide us on what to bill. But one thing to take into consideration is in Tanzania, we're not allowed to have contingency billings or contingency fees. So we're restricted to the remuneration order, and of course, the negotiation between the client and the advocate. When it comes to best practices, I think for most lawyers, as you're aware, the few things are very important, and things that are the current trends in Tanzania as well. Most law firms are already doing this. Is number one, having clarity and transparency in terms of how the billings are going to take place. Most of us have the remuneration agreement, but also we do itemize on our invoices on what are the professional fees, what are the disbursements. If there are any reimbursements, those are also claimed. So you just need to make sure that it's clear and it's transparent. Fee arrangements need to be discussed and agreed upon prior to engaging in any case. Most of the times we've noticed that a case may have various applications. So it's always important to basically build those applications separately so that you can also have a recovery when it comes to your bill of costs and taxation. Putting down the scope of work and fee structures clearly. The third thing that is very important is regular communication with the clients, which is very, very important when it comes to best practices in billings. I have noticed that whenever there are disagreements in payments, we always go back to what was communicated. And if that is not communicated rightly, then it may create a miscommunication or misunderstanding with the client. In Tanzania, and specifically also most of us practicing here, we look at a value-based billing. So the focus is always in delivering value for the client. And so we mostly do not focus much on time billing by time. I think majority of the law firms and lawyers do not bill by time, but we estimate how much time we're going to spend. And the advocacy remuneration order is very clear on hourly rates as well. Although in the previous workshop that we had, which was organized by the Tanganyika Law Society, we did see that when it comes to contentious matters, somehow the rates when it comes to hourly billings may be very low. There are law firms and lawyers charging a higher rate. Hence, I raised a caveat in the beginning to say that most of us in Tanzania are actually using the advocacy remuneration order as a tool for guidance and negotiation. Some of the ethical considerations when it comes to billing is, again, I'll refer to the judgment there, where you need to avoid overcharging. So the charge has to be reasonable to the work that you're doing. It has to be fair. So when it comes to fairness, I think that is very important when we're looking at ethics in terms of billings. But also another thing that needs to be considered is that there shouldn't be any conflict of interest. So in case there is any conflict of interest in taking on the work, and if it's going to affect your billing, that needs to be disclosed earlier so that the client is aware. And of course, compliance with the advocacy remuneration order. So we always have to try and see that we are within the limits that are prescribed by the law and not going too further or too less, so that there is value to client, but also the advocate feels that they have performed a certain task. Like I said earlier, a couple of challenges in billings when it comes to our law in Tanzania is that most of the times when you look at for non-contentious matters, the rates provided are somehow higher. So that was also discussed in a previous workshop that we had, that sometimes you can't charge a very high amount because the rates provided in the advocacy remuneration order is higher. For example, sometimes when it comes to, for example, a sale of a property, it says that you charge 3%. Now, sometimes that 3% could be really high. So, maybe the value of the property or the sale is very high, but that 3% going to the lawyer, the client may feel discouraged to pay. So lawyers have been reducing the amount, but sometimes when the property value is very low, then that 3% might sound very small. So hence my caveat on the fact that we use this as a guiding principle, and not everybody follows exactly what's in the law, and hence the taxation officer has the discretion to choose and decide what to offer. I have seen that in the past 1 or 2 years, our advocate remuneration order, the billing processes, the way people are now perceiving billings is evolving in Tanzania. We are trying to meet the client expectations, the current economic growth, but the education and the knowledge is still less. So there is a lot that needs to be put in, and hence I was very excited to be a part of today's webinar, because I think 2 months ago we did host a similar workshop for lawyers at the Tanganyika Law Society, and it was very interesting to see that most people were not even aware of what is provided in the law. And so there is very little education from the lawyer side, but there's also very little education from the client side. And a lot more effort needs to be put in to see that we can balance this out so that the clients don't feel that we're overcharging, but also the advocates are basically remunerated fairly for the work that they're doing. I think I will end here with just a brief summary and my thoughts on emerging trends, and perhaps we can go delve into discussions later. Thank you, Alan.
Thank you very much, Wally. Thank you very much, Wally, for the very insightful discussions and the trends you've presented us that are happening in Tanzania. I have noticed that it could be a trend all over East Africa that we advocates aren't billing per hour, but actually billing by the value of the work we are giving to our clients. Now, as we were going through, a question came through. What are you doing for the undercutting advocates? Now that you're talking about your rules or regulations being a bit higher, doesn't this bring about the issue of advocates undercutting or underbilling? Doesn't it affect the quality of your practice and services that you are rendering to?
So undercutting, I think, has been a very, very big challenge for us in Tanzania, because we are actually always fighting and facing this challenge. But there is always a saying that if you are good at what you do, then the clients will obviously come and pay for the value you're providing. So yes, there is a lot of undercutting going on. Yes, there are lawyers that are charging, probably even 90% less than what you're actually supposed to be charging. But this is because of the lack of education provided, but also, unfortunately, our law society has not yet gotten to the stage where they can govern these billings or they can regulate these billings. So I would say that regulation of these billings is a challenge to date, especially when it comes to some of the non-contentious matters, because there are lawyers who are charging 200,000 Tanzanian shillings to draft a contract for a property sale worth 1 billion shillings. And there are lawyers then obviously charging the fair value. So clients always are going to look at something cheaper. So unfortunately, undercutting is a very big problem in Tanzania. But this is also because, as I said, that the society has not yet managed to sort of regulate it properly and see that these people who are undercutting are actually taken to task. Yeah, I think that I'll stop there.
Okay, thank you very much, Wally. Just another quick one before you go off. In Uganda, we are having a challenge of a discussion of young lawyers and senior lawyers, or the challenges generally facing our legal practice. Would you, or is it a practice in Tanzania that you have young lawyers billing differently and senior lawyers billing differently? Would you think that would come in handy? Because the senior lawyers will be saying, I have vast experience and all that. I understand you've said that, of course, when the work is good, when the experience is there, the clients will come in. But do you think the senior colleagues in the profession should be entitled to this, or it should come to the value, or this is when we now go to the time dedicated, because the international firms are also around and they are applying the time. The time spent on the case is what they're going to bill you for. So what should the case be for our case in East Africa?
Well, I think the situation is not very different from Uganda. We do have senior lawyers charging higher fees than the young lawyers, mostly because obviously now we have more than 10,000 lawyers or advocates in Tanzania, and the market is saturated. The economic situation is also contributing towards it. The people are not willing to pay higher fees. But in my humble opinion, I don't think there should be a difference between who should charge what. I think it should be regulated by law. That's the only way we can all give a fair fee, but also we can all make a fair remuneration. Yes, there are certain senior counsels who would maybe rate themselves a bit higher. So when we send our fee codes, not just in terms of seniority, but also sometimes in terms of your position at the firm. So you would tell a client that if you want to meet the managing partner, the rate is $350 an hour or $250 an hour. And if you want to meet just a partner, it's maybe $200 an hour. I think these are rates put in terms of positions and seniorities, but it's also because these are the trends in the international space. So sometimes when you're also billing clients in an international space, you are trying to match their level of billing, which they're used to. Because sometimes they would look at you and say, why is this lawyer charging me so less? And there are clients who walk away because you've charged less, and they would go to somebody who is charging more because they feel that is where they will get value. So it is a very tricky situation, but I would say, in my humble opinion, if the law can be there to guide us, I think that is where we should be guided by. However, we can't stop seniors from putting an amount to their experience, because they do sort of feel that they've earned it. I mean, I've been practicing for 14 years now. So my fee would slightly be higher in terms of my hourly rate, because it's my time that I'm selling. It's my experience, my wisdom, and I've been through all these challenges. I know how to navigate them, compared to somebody that just graduated law school and has no experience. So in all fairness, that would obviously come into place. And the client also would feel more prestigious that he is actually dealing with a senior and paying an X amount. So sometimes it's actually the client's expectation that we're trying to meet.
Thank you. Thank you very much, Wally. I can hear you. I can hear you speaking. And right about now, the other issue that you would probably answer in the Q&A that is coming up is that at other bar associations, what the laws set or the regulations set is the bare minimum below which an advocate can't go to. Does the Tanzanian bar set a high standard, or does it set the high ceiling? But those you can keep for the Q&A. You will respond to that. Right about now, allow me, colleagues on the call, call upon our counterpart who has also been with us, and we are blessed to have you, Laston Gulume, a practice director and head dispute resolution at LP East Africa. Give us the insights on the remuneration of advocates in the country, that is Uganda, the emerging trends, best practices, and ethical considerations while billing clients. Would our Supreme Court, given the circumstances, interfere in that? Does it have the jurisdiction and all that? Okay. As you come on, Glume, I would like to call upon our participants and attendees to kindly send those questions, keep those questions coming to the panelists. We shall have time to respond to them just right after Glume. Welcome, Glume.
Wow, thank you so much, Alan. I want to thank also my fellow panelists that who have just made previous presentations, quite very interesting presentations. What we are discussing on the billing and the trends is really at the heart of any advocate's work. After you put in the hours, you put in the time, of course, you put in the expertise. I love what Wally said earlier, that what I'm selling is my time. So the expectation is that that time should be fairly compensated. In terms of the insights from Uganda that we have been able to pick up, we realize that in any jurisdiction such as Uganda and other East African jurisdictions where you're dealing with a regulated practice or profession, of course, the rules will set what they are saying, but also there are other external factors that will influence how those rules are applied. Wally earlier said that not everyone follows the rules, and I'll be honest, even in Uganda, it is true that not everyone follows the rules. So what are the trends in Uganda really? Like any other jurisdiction, what we've been able to observe so far is that remuneration of advocates' services, of course, increasingly has been influenced by how complex the legal practice continues to become. We are having tools that as advocates, you have to adopt, you have to spend money on to be able to serve your client. And Alan, earlier you had said that you have the big firms also coming, and what is their preferred billing or their usual billing? They are billing you per hour, and they are giving out these hourly rates that you have to match because you're looking at drawing from the same kind of market and the same kind of clients where you are getting instructions from. So that also has influenced the way advocates bill. When you have a client who has an option to choose between a law firm or an advocate who has a local firm, if I may use that expression, and one who also may look at an international firm or a regional firm, they are looking at what will the bills look like. So what the landscape is showing that it is evolving, and advocates are expected every time you send a quotation to a client. Probably Alan has sent one, last one is also sending one, another advocate has sent one, and they are comparing this. Interestingly, what enables a client make a decision whether to go with this advocate or the other advocate, sometimes it could be because your bill is too small, or your bill matches what they expected, the high figure they expected, or it is too high for them to afford. So the trends, most clients, at least when you look at surveys, of client feedback, they are looking at something that has a fair, balanced expectation. And those are the billing practices that we want to highlight from the Ugandan perspective. And the factors here that are influencing these kind of billing practices, of course, you look at the legal issue involved. If you're dealing with a complex legal issue, and the client has given you probably a matter of probably 5 or how many millions of dollars, and you send them a bill that does not demonstrate that you understand the value that you're dealing with, or what you ought to defend, or what you ought to mitigate, then the client has a question mark of whether you've understood the instruction. But also, even in such instances, the client will not want to get a very exaggerated bill. So the time also that you expect to put in, that's where you see there are matters where if you're looking at mostly litigation, you can never cap that will spend probably 10 or 15 hours doing this litigation work. Even for arbitrations, interestingly, you can start an arbitration and you know the procedure in arbitration, you know you'll have these meetings, you know you have these procedure orders. Before you know it, sometimes for mostly complex arbitrations, you end up spending more time than you anticipated. So if you cap maybe the hours or a fixed rate, it could end up being prejudicial to the advocate. Or if you exaggerate it, then like we'll later see in one of the decisions made by Justice Mobiro of the Commercial Court, the client may think that you either intended to be dishonest or you just didn't understand the work that you were taking on, and of course the complexity of the matter that you're handling. So the shift in terms of trends, the shift that we are seeing is driven by, of course, the need for more transparency and clarity. Any client today, before even they say anything, they will want to know, what is my bill going to look like? Sometimes you even have not received the full brief of the instruction, and the first thing the client is asking you, how much are you going to charge me? So for advocates, despite having a law, the Advocates Remuneration and Taxation of Cost regulations taken or made under our Act, under our Advocates Act, which allows for agreed fees, you can have a fixed fee. This is usually simpler for non-contentious matters, where you can negotiate the hourly rates or you can negotiate the capped hours, and you try to manage your time as an advocate and also deliver what the client expects you to deliver. Interestingly, I think earlier on, for the people that could have read the case that Martin was taking us through, an issue was raised on interest, although it had not been part of the questions for which leave was sought to be presented to the Supreme Court. But I thought was important for the Ugandan context, at least our regulations provide for 6% per year of interest on the disbursement and costs from the date, 1 month from the date of an advocate delivering their bill to the client. And then we have under our rules where contentious matters are provided for and how the bills are taxed in the contentious matters. But what I found quite interesting to share with us this afternoon is that as last year was ending, about 2023, as it was coming about on the 3rd October, Justice Okello, one of the High Court justices, while they were dealing with the matter, they laid out about 19 principles that ought to be considered when you're dealing with the taxation of bills of costs. Now, of course, these are in contentious matters, and every time you're talking about an advocate-client bill, of course, it is the advocate who was instructed by that client, against whom the advocate would want to recover their costs because the advocate is entitled to be paid. Among other things, I won't go through the 19 principles, but what I found interesting that yes, the judge still maintains the position that has been in all our cases, that the taxing master or the taxing officer enjoys a certain degree of discretion. So we don't have a magical formula that will tell you if you put this and put that, then it will give you the ultimate figure. So in taxation of bills of costs in Uganda, according to that authority, there is latitude, there is a discretion, but of course that discretion is exercised within the parameters of the schedules and the bare minimum that our rules or regulations provide for. And of course, there is need also, what I learned very early in the profession is that when it comes to taxing bills of costs or the advocate's remuneration, it should be that kind of remuneration that can enable, attract, and recruit, recruit good talent into the profession. If advocates are poorly paid, you're staying up to stress yourself and find a solution for the client, then definitely you will not have the good talent attracted to the profession. And yet, friends, we can agree that a good and efficient advocate will do so much to help a client either mitigate, to help a client, put their affairs in order, more so when a dispute arises, of course, help the client resolve their disputes. But what have the courts said about billing? Now, specifically when it comes to an advocate-client bill of costs, I found this decision, it's quite an elaborate decision. If you have some time, I would encourage anyone to read it. The miscellaneous clause 52 of 2022, the judge quite delves into a very interesting discussion on what are the considerations when you're dealing with billing and when you receive instructions as an advocate from the client. The decision is in respect to an application that was made by one of the law firms here in Uganda, applying for leave to have their advocate-client bill of costs taxed. And it's actually interesting the extent to which, as advocates, we will be required to be held by court to a very high standard. And this, among others, this is what the judge highlighted, that, you know, when you receive instructions as an advocate, first you must, and the words, I'm picking this directly from what the judge held, that you must provide the client with a cost estimate that is accurate as the circumstances permit. Now, it's first an estimate, and also the judge uses the word such as accurate. So if you have an under-quoted bill or a very high bill, it puts you really in a funny situation for a client who may already from the onset begin to put up walls of certain mistrust. Why? Because you have to bear in mind that any inaccuracies in invoicing can lead, of course, to problems in your advocate-client relationship. And of course, if you're looking at maintaining a relationship with a client, you want as much as possible your conversation on your remuneration to be as straightforward as possible. The judge further says that by having inaccuracies or inconsistencies in your billing, it can lead to losing, it can lead to an advocate losing confidence. The client will lose confidence in that advocate. Why? Because they will question whether the inaccuracies, are they genuine, that maybe you had not understood the case, you had not understood the scope of instructions, you had not understood the extent to which you're going to be engaged, whether hourly or the human resource you're going to need, or other resources such as IT and the different resources you may need to execute that work, or is it an outright act of dishonesty? Now, of course, that dents an advocate's reputation. Here, Alan, you had asked earlier about bills of senior lawyers, bills of young lawyers. When it comes to reputation, the trends really are that, when you have been in the game for a while, it also helps you not to really over-negotiate your bill, because mostly for any client going to a senior lawyer, they want to work with that senior lawyer. For the junior lawyers, you're usually trying to court and onboard the client. So the clients may also begin to question your legal abilities. More so, the moment you have a complex matter, the stakes are high, you're dealing with huge exposures, and you're quoting as though you're dealing with a small matter. The client may question your ability, really. They may question your ability, and may also question your understanding of whether you will be able to deal with a complex legal matter if your billing statements are not accurate. So what are the best practices, really, from what court is saying? What are best practices when you study around, this issue of billing and lawyers and clients, and also the value of an advocate-client relationship and how you foster that relationship? The surveys have indicated that clients expect clear communication, that, when we are talking money, let's not leave too many gray areas. In fact, leave no gray areas at all. Are we dealing with an hourly rate? Are we dealing with a fixed rate? Are we dealing with billing that is going to be determined in accordance with the rules that are set for advocates? And of course, since you're telling a client who is not an advocate, you may want to a bit explain what are those rules and what should they expect from those rules. It includes informing the clients of the potential costs associated. So sometimes the clients will ask you, you're going to do for me this work, what would be the cost? You're going to file this case, what would be the cost? And you need to know at the point of filing, maybe what would the filing fees be? You could estimate before you file, but the ultimate filing fees would be determined at the point of filing. So if you are an advocate who has not done your background work, and you end up, surprising them with a huge bill, just filing fees alone, then it would send mixed signals to the client. Another best practice, of course, is reasonable fees. Friends, we're in the business of providing a service, but as we are providing this service, it is a business. You negotiate with the client. So the expectation is charge for the actual work done. Sometimes the client will come and they will have underplayed the work they are giving you. You may need to help them understand the level of engagement they are going to engage you. Because when you overcharge midway, you're revising fees too much. One of the other best practices we have learned is that in your engagement letters, you have to be very clear that if the scope of instructions change, we'll have to retalk about this bill. So if that's not in the engagement letter, midway instructions have changed, the client is going to insist that, no, we agreed on these fees, you should be able to demonstrate to them that midway, when the scope of instructions changed, it grew bigger, we have an express provision in engagement letter that, look here, you can't be paying for us to do work of these many hours, and yet you think we are still working with fewer hours. Why? Because we have a fiduciary duty as advocates and it's owed to our clients, but that does not mean that then you don't streamline your billing to be able to be paid what is due to you. The other best practice, both international firms, firms that have been in the game for a while, is always just have an engagement letter, have instructions issued in writing. Why? Because it enables you to clarify expectations. It enables you to prevent disputes as much as possible. Of course, it does not deal away with all disputes, but at least it helps you to mitigate. Sometimes, as advocates, we get to court, and the issue before court is whether or not the advocate was ever instructed. And that is after a client has jumped ship, changed lawyers, but then there is nothing in writing. There is nothing in writing, and such an advocate can face challenges. But the agreements would detail, how fees will be calculated. Sometimes they may not have the express figures, but at least there will be a guiding tool. Then the client-centered approach. For most research out there, practical law firm management, practical client management is talking about a client-centered approach to practice. When a client comes to you, is the priority and the interest over maximizing fees or giving the client the best service and attending to their interest? A happy client, we know at least usually is a paying client. When the client is happy, their issue has been dealt with, it's usually a paying client. Not all happy clients are paying clients, but at least on average, you will find that where a client has had the expectation met, it eases this conversation of billing. And of course, the client-centered approach helps you to foster a long-term relationship with clients. On my part, really, when I started out practice, I would always struggle with, I'm having this conversation with a client who has been assigned to me, but I also have financial targets to deliver at the firm. So how do I account for my time? But then your managing partner, your line supervisor is telling you it's important, Laston, to cultivate a relationship with the client. So how do you have that conversation? First, you establish trust. When you establish that trust, then the moment you're mentioning fees and the client trusts that you have their best interest, that conversation is easily managed that way when there is already trust established. Ethical considerations. One of the things that I identified that the judge pointed out in the case that I highlighted earlier. Of course, there is a fiduciary duty between advocates and clients. The advocates owe a fiduciary duty to the clients to act in their best interest. So that duty also includes us being transparent about our fees and avoiding, conflicts of interest. You can have a big case. It's a case that can almost help you achieve all your targets. And you need the client to know that this case, the expectations are this and that. So you're clear of that. And of course, you avoid overreaching. Overreaching here is used in the context of, breach of trust. It's one of the things that the judge highlights in that application of Yenchak here, where he says that, you're insisting, give me an immediate response. I've sent you my bill, pay now. And the judge, in fact, used words such as it could be seen as undue influence, bordering undue influence, because the advocate is insisting on something that seems to be unreasonable. And of course, regulatory compliance. We know that including our Court of Appeal and our Supreme Court back here in Uganda has also dealt with taxation references where parties have failed to agree. Specifically, if I could highlight the Court of Appeal decision, where the Court of Appeal was taking on a taxation reference arising from a constitutional petition. So it was a constitutional reference where you had a bill of, I think, over 23 billion also filed. And from the 23 billion bill of course that was filed, this is the constitutional reference 27 of 2013, which was arising out of that constitutional petition. And in filing a bill of 23 billion, the taxation officer allows 12 billion. Now still, the decree holder or the successful party was not happy. So they take out at a reference, and this reference goes before Justice Kenneth Kakuru, now deceased, may he rest in peace, and he slashes it to 21 million Uganda shillings. This is not even Kenyan shillings, to 21 million. So they had been allowed 12 billion from the 23 billion, and it's further slashed down to 21 billion. If you read most of the cases in Uganda, you'll find that whenever courts are dealing with issues of taxation, that this decision will feature so much. What are we saying in terms of the trends, really? Alan, as I come to an end in the interest of time, the trends are really that we have to know and we have to develop a mature way of dealing with clients and be candid about fees. And the conversation about fees is not really one that you just have a mathematical formula about it. Like I think Wally said, some clients will not want to work with an advocate who charges small fees because they don't think that that's the value they are getting will be one of the small fees they are receiving. Other clients, even big corporations, even multilateral corporations, you'll find that honestly, the kind of bills that they are paying the lawyers is not commensurate to the big names that the multinational corporations have. So it's something that we have to be very intentional in learning and understanding your client, know the rules when it comes to advocates' bills, and also apply the value of relationship and persuade. Lawyers, we are good at persuading the other side. We are good at persuading the judge to agree with us. You may need to negotiate, of course, our bills with the clients. When it gets to court determining whether or not, it's court determining whether or not we have billed our bills, of course, following the rules. That one, we can always argue and justify why you think you should get a higher figure than a lower figure. The Kenyan Supreme Court Authority, of course, has big implications in Uganda. We are in East Africa. We rely on each other's decisions. And when it's a decision of the Supreme Court, definitely, it would have an implication on how bills of costs are dealt with back here in Uganda. Alan, thank you so much. Those were my quick takeaways and thoughts from Uganda.
Thank you very much, Laston. I must commend you for the elaborate discussion of the Ugandan trends and emerging challenges that we have to face in the country as we go about billing by advocates. My takeaways from your discussion for our attendees are that number one, communication on what is agreed upon by the advocate and the client is key. And then the fact that the filing of the bill is not so much the best focus, but the value. That is the value you give to the client. Can we create that relationship with the client before we front the money talk? Once that relationship is created, the client will almost believe whatever bill you are giving them. This is what Senior Wali was alluding to, that comes with seniority. But Laston is saying, even without seniority, even when you're a young lawyer, can you create this relationship with your client? Thank you very much, Laston. I'll also want to commend you for your time management skills. I'll now call upon our last panelist before we go into the Q&A briefly to tell us what the trends are in Rwanda and how they are managing. What are the best practices? Anything to learn from the Supreme Court decision in Kenya? Does it rubber stamp what they already have? Are they threatened or otherwise? Welcome with me now, our dear colleagues on the call, Mr. Colin and Gatete.
Okay, thank you so much. Thank you very much to the presenters who spoke before me. It was very, very insightful from Tanzania, Kenya, Uganda. And so it is very interesting. I was able to learn a lot. What I noticed is that in Kenya, the details that they pay attention to in terms of billing is significantly higher than what we have in Rwanda, actually, because I think as Senior Counsel Martin mentioned, he mentioned, about something that kept coming party to party, divide by one. So these are things that are not very common in Rwanda. We've not had this kind of issues being addressed here. And therefore, I'm going to take you through the practices here in Rwanda about in terms of the billing, how it operates here. So to begin with, Rwanda, as you may know, Rwanda is a civil law country. So meaning, well, it is previously a civil law country, which is slowly adopting common law practices. And so some of these precedents may not immediately have an impact on how fees, the billing is going to be done in Rwanda. And in addition to that, Rwanda seems to have a significantly different way of okay, if you look at the law, if you look at the regulation, we have a regulation, maybe, it tends to give room, but the practice is slightly different from what I've been hearing the speakers before me talk about. Now, let me try to, if I understood correctly, beginning with the judgment, the Otieno Ragot versus Kenya Airports Authority, what I managed to capture is that what the court was doing, the court was trying to emphasize more on clarity on advocate-client agreement regarding the fees. They were trying to put clarity in terms of reasonableness, what would be considered reasonable in terms of the billing practice, and in relation to their scale. Well, that's what I managed to pick. Now, what the court was doing, we already have something of the sort in Rwanda, even without the precedent as such. So let me take you through what the practice is in Rwanda. So to begin with, we have a law. We have a law which is which we strictly adhere to, and it is the Rwanda Bar Association regulation #1 of 2014. It's a 2014 law, which means it's 20 years. It is 20 years, 10 years this year, which fixes the scale of the fees of advocates. Now, that law is the one we use to determine or to do our billing in Rwanda. Now, if you look at the main issues that are in that, or the main principles that are covered in that law are things that also the other members have been talking about. 1, transparency. 2, fairness, especially to the clients, or both sides, but especially to the clients. And lastly, conformity, uniformity in terms of the fees, because something we discuss later. I'll discuss that a bit later. Now, the fees, the way they are classified in Rwanda, they are classified into 4 main categories. So some they've mentioned. So we have what we call the extrajudicial service, what we call services for and drafting acts, and then special services, and then recovery of claims from contracts. Now, the 3, if you look at the law, tends to as the days have come by, the law has become a little bit irrelevant on some issues, because some of these issues are cutting across. So, for example, if you look at what the law provides for as the current extrajudicial service, it includes consultancy, advisory, and assistance on certain transactions. And then the one for services and drafting is basically drafting contracts, wills, mortgages, and so on. And then what they call what is referred to as special services is basically assistance in different services intellectual property registration, company registration, assistance in before the labor inspectors, before it goes to court, and so on and so on. And then lastly is where you get the contentious issues being addressed, going to court for criminal and non-criminal matters. So those are the way the scale is designed is that it addresses our fees in those 4 categories. Now, what are the emerging trends in the billing practices? First, as I think Mr. Wali mentioned, we have something that has been, that has become very common, and it has actually always been for us. It's not that it has even become new; it has always been there. So it has always been kind of a flat fee, what we could consider a flat fee or fixed fee for work being done. So in Rwanda, as we speak, most of the transactions, or most of the legal fees that are, or the billing, or the billing trends by the lawyers in different matters, be it contentious matters or transactions and so on, tends to be a fixed fee. However, there's been some of the, I think it's last one who mentioned, there's been entry of these international firms. Now, these international firms have brought in more aspects of billing by the hour. Now, billing by the hour has its advantages, if you may say, because it is fair for both ends. However, it comes with the most fair way to do it comes at a bit of a cost that not so many lawyers will be able to afford. If you pay attention to how this billing per hour is done, especially in terms of transaction, it has been done using softwares which sometimes have not been, if you look at the cost, they have not been very affordable for so many lawyers. And so the issue of billing per hour becomes a challenge, because justifying, how many, whether the hours are the actual hours becomes an issue. So whether we are using fixed or hourly rates, we are using a lot of capped fixed fees. And then someone also mentioned about contingency fees. So basically what we could call success fees. Success fees, our laws are very clear on that. There is what they call pact quotalitis. Pact quotalitis, it is the French, not French, the Latin, which basically prohibits any arrangement based on success. What the law provides for here is that you may make the contingency as an additional fee, but not solely. You cannot have legal fees solely based on contingency fees. So as a result, there's been we don't have, the law is clear on that. It's either you do fixed or or per the hour. However, you cannot do contingency fee unless it comes as an addition to either of the above that I just mentioned. So
and I think I'm losing you.
Sorry?
I think we had lost you, but we can hear you now.
Okay. So what I was saying is in terms of the fixed and hourly rates, we have two in Rwanda. I was talking about contingency. Contingency is prohibited. However, it can be put in addition to the fixed and hourly rates that I mentioned earlier. Then there is something I mentioned about the about the other arrangements we have is also retainer agreements. So where we have, especially for companies or these big organizations, where we have organizations coming in where firms and organizations come into agreements where we have a monthly fee, which is usually what we call a retainer here. So a monthly fee. So in other words, the fee, the lawyer and the firm will agree on a monthly fee, or a yearly fee or quarterly fee, which is paid, and then the client will be able or should be able to send all legal issues they may have their way. So we also have those trends coming up with those kind of arrangements, those kind of retainer arrangements, where you have a fixed fee for the month, every month, and then the client can send the work your way as it comes in. Then, lastly, something I also have to mention is someone I think mentioned, I think it was the Alan's inquiring about whether we have a maximum or a cap, a maximum on the fees. And what I can state here is that in Rwanda we have actually both. We have both, and both are prohibited. So if you look at our scale provides for a minimum and maximum on both ends of the.
Hello, Colin. Do we still have you? Gabriel, please guide if we still have Colin.
Alan, I think Colin has seems to have dropped off.
Oh, sorry. As we wait for Colin to return, we can now delve into the brief Q&A session. I see a few questions that have already come on board. Laston, can you help us guide on how best we can respond to the bills? How do we respond to the bills? Do we file submissions as the practice has been, or do we have any other alternatives? I believe the Ugandan law has gone ahead to say that even after filing the bill, parties can sit and have a pre-taxation meeting. So kindly guide, thank you.
It's a percent.
Yes, thank you. Thank you so much, Alan. Responding to the bills, really, here, when you're going to get paid, you need to be either a very good negotiator, or you must know if, more so if you're the one who has filed the bill, or if you're the one opposing the bill, if you have good, proper grounds to oppose that bill. And this is why. This is why. I think Wali's microphone is unmuted. Yes, and this is why. Sometimes it's an awkward situation that you're not against your colleague getting paid, but also if you're the one opposing the bill, you have a client whose interest you're representing. So you're right when you say, and you're spot on, Alan, when you say that the pre-taxation, which was introduced by our rules, it's now a legal requirement that you have to have a pre-taxation session where, as advocates, you sit. Because as clients, the client may not be able to understand why is this particular thing opposed, and why should it not? Why should it not be on the bill, or why should it be on the bill? So the reason as to why you have our regulation 13A that provides for the pre-taxation meeting of advocates or parties. I know that the rule says all parties, but usually in that meeting, you're having advocates participating in that pre-taxation. You're negotiating, you're saying, look here, this is what I have done. And like I think one of us earlier said, Wally, or something, that that sometimes you have bills that have been exaggerated. So as an advocate representing a client against whom a bill of costs has been filed, you want to actually know, what does the law provide for? What does the law allow? What does the law not allow? That is one. Two, should you find yourself that you have to proceed now to have submissions made on the bill of course. When I was reading that constitutional reference on the taxing of that bill of course before Justice Kakuru, from 23 billion to 12 billion to 21 billion, you may want to know how far you want to go when you look at the odds, because sometimes you have bills being slashed to almost really peanuts. Sometimes you have bills really that should have been awarded more money being awarded peanuts. So it's a strategic decision that an advocate has to make. Why? Because whereas the case that we are discussing, the Kenyan Supreme Court Authority was dealing with an advocate-client bill of costs, that of course was following certain thresholds that were rising from a party-to-party bill of costs. If you're going to recover costs, we know that if you are able to get the judgment data paid, then as a lawyer, of course, you're likely to also be paid much more quicker. But if that does not go through, that's where you end up having this advocate-client bill of costs. It does not matter whether or not anything has been recovered from the other party. In principle, an advocate should be paid their money. So if you're dealing with a bill of costs, which is a party-to-party bill of costs, you're looking at still negotiating it. If you're dealing with an advocate-client bill of costs, already there is that protection in law for which clients enjoy, that you must first apply to court for leave for you to be granted permission to have your advocate-client bill of costs taxed. I've just demonstrated to you the decision from Justice Mubiru that it's not automatic that when you apply as an advocate to have your bill of advocate-client bill of costs tax, it's going to be allowed. And those are the considerations that you ought to consider. Alan, I hope I've tried to do justice to the question, but I don't think there is a straightforward answer on how we should respond to bills. Each case, you should handle it on its own facts.
Yeah, thank you, Laston. But before you go away, can you guide us on the thresholds? How far below they can go, and then how far above can one go when they are billing? Because in some cases, the Advocates Act has been very clear. It has set the minimum, but also it has left it an open provision that with the consent of both parties, that is the client and the advocate, a different fee or figure might be agreed to. Thank you. Kindly guide us on that.
Yeah, this issue of underbilling, for example. One, I have learned early in my career that a client will pay for value. And I'll use this example. When you go to any cafe Javas to have probably the same tea or to have the same to have the same dawati or whatever you're ordering for, which you can get elsewhere, you realize you're likely to pay a bit of a higher amount for the same product you can get elsewhere. Let's take an example of just water. You go to a 5-star hotel, what are you going to pay for? You're not going to pay for that water the same rate you get it downtown. The point really is that you first need to be able to demonstrate the value to the client. That is one. And then two, most importantly, there are rules. You see, today, if you're underbilling to get work, if that client comes back to you again, they are going to expect to pay that low bill that you underbilled them. So look at the rules. The rules provide for, in Uganda, at least if it were court matters, you have at least a rate for every hour. That's the baseline you're looking at. Then where you have built your value over time, you don't need to go by the bare minimum. You need to demonstrate that my hour is worth this much. Then how far can you go? Like we say, you need to study and know your client. If your client is a deep pocket, you don't want to be sending them bills as though you are too sorry that they're even considering you as their lawyer. The client wants to be proud to have you as their lawyer. They want to be proud to pay for the value that you are giving. Unfortunately, I've not found a mathematical formula, not even an AI app to tell me, you see, Laston, if this client is this, then you should bill them this much. Because at the end of the day, the decision makers who are deciding whether to pay you that much or to pay you this low are human beings. Have a relationship with them, show them the value that you're giving, and then set your standard.
Okay, thank you very much, Laston. We'll now go to our next panelist to give us Colin, you are back. Unfortunately, we had lost you.
So sorry about that. I think it went off. I had a notice I was going offline. Things were disconnected here.
Okay, just a minute. Let's have these Q&As and then we'll get back to you as we conclude, because I see time is not on our side. For now, can I call upon Martin? There have been a few questions in the Q&A, and people are wondering, are you really defending the Supreme Court decision? And then the other thing is that as we talk about threshold, what do you advise? Martin, kindly come back and tell us that. Thank you.
Yeah, thank you. I like that question because it actually confirms the controversies that I talked about. The position in Kenya is that the Supreme Court decision becomes binding. So it doesn't need my defense. And even if I had not represented the authority, it would still be a question for debate and for discussion. I think once you look at the facts of this particular case, consider what the court had. And I started by reading out the pleading that was made, where then you would determine the subject matter. It was extremely vague and unascertainable. So then there are two maybe takeaways that we need to come up with there. The whole question of our pleading to be as clear as possible, but also something that Laston mentioned, I think the experience of having an engagement letter. It doesn't matter even if it is me now engaging KAA now, even after such a kind of a win. The best way is to have an engagement letter, an agreement prior to commencing the work, either by way of time-based or by way of evaluation, and based on the parameters that we have discussed, scoping the work and providing for those options where you can revisit the scope if the instructions keep on mutating as you go along. Otherwise, there is no way of completely knowing within which limit. But as for the thresholds, I would not say that there is a clear line where the matter is not, the value is not very well ascertainable. It is difficult to put thresholds, but I think there have been agreement across board on the whole question of reasonableness, the whole question of motivation. And I agree with what I think Wally said, if a client comes to you with their 20 years of experience, there is something they are looking for. And that what they are looking for has a bigger value than just anybody of 5 years. And this applies even in arbitration. Actually, the Chartered Institute of Arbitrators gives charge out rates based on the experience. So there is that value that you bring in because of experience, and you shouldn't feel shy to charge based on that. But if we have an agreement, then we will reduce these issues. As to whether we are to defend this judgment, I'm hoping maybe in future, probably a new set of arguments will come up, and the Supreme Court is able to review its own judgments, but on very limited parameters. I think there is a decision of OUTA that talks about situations where it can review, but until that happens, we have to go with the parameters that have now been set. Thank you.
Okay, thank you very much, Senior Martin. We'll now go to our last question, which I am going to ask our other panelists to ably handle. The question I saw in the chat relates to how best we can regulate this undercutting and underbilling amongst our societies. Wally, I understand you've served in various capacities in the leadership of the Tanganyika Law Society. Kindly advise us. And Yes, I was going to request Gabriel to kindly share the link to the judgment of the Supreme Court, but I see something has been shared. Kindly confirm, Gabriel, if that is it, and share it to our attendees. Thank you very much. Welcome, Wali.
As I briefed earlier, that the issue of undercutting is a big problem, of course, but there's two schools of thoughts about it. It's, as I said, one is that if people do not undercut, how do they survive? You know, they're the young lawyers, the lawyers who do not yet have their personal brands and stuff in place, who are basically charging to survive in this society. But then, of course, there's a second school of thought where you need to abide by the law, and obviously we have to put our practice, a standard fee structures where we all are, you know, in a position to obviously prosper and grow and make a living, decent living with our profession. In my opinion, and this is something that I've been always discussing even with the Law Society, is that the Law Society in Tanzania, but I think elsewhere as well, I belong to two law societies, one, the Zanzibar Law Society, I'm an advocate there, and the Tanganyika Law Society as well. I just wish there was a way to regulate how and what people are billing. For example, in Tanzania, even law firms are not regulated. They're not governed under the Law Society. So it's very difficult for us to be audited, or for lawyers and advocates to be audited on what are they doing, how are they performing, what are the billings, what are the invoices looking like. And I understand that lawyers can collude with clients, but right now I think every jurisdiction has EFDs. We're regulated by the taxman. So it's not very difficult for law societies to regulate and govern law firms and see that how are they performing, so that those lawyers or those law firms that are undercharging or undercutting, not following the guidance of the Advocacy Remuneration Order, can be, you know, penalized and taken to task. Because if we don't keep a standard, what will happen is that there will always be these issues where majority of the lawyers are sort of prospering, not in terms of making revenue, but in terms of getting clients and creating an impression for the clients that the other lawyers are expensive. So this cheap, expensive thing is going to happen. So I would say the only best way is for law societies to govern law firms, audit law firms, understand their billing structures, their invoicing, and also make sure that we are all compliant to the advocate remuneration laws, and that we're not undercharging or undercutting, but we're also having a fair billing. Thank you, Gabriel.
Okay, thank you very much, Wally, for the wonderful insights, and I believe that is a very well answered question. Okay, now I'll ask us to first of all request the ELS, Gabriel and your IT team. Can you kindly accord us about 10 minutes such that we can have each of the panelists give their parting shots? I will, however, begin with Colin, whom we had lost, such that he can briefly conclude, but also give his parting shots. Then we'll proceed with all the other panelists to give their parting shots. Thank you very much. Welcome, Colin.
Thank you very much. Sorry about the inconvenience before. So I will be very brief about, like most of the members had mentioned, about things which cut across. One of the things that they mentioned is about undercutting. I'll begin with where Mr. Wali stopped off. We must agree that undercutting ultimately, we must even, teach anyone who would think that it is in their best interest that it ultimately affects your brand, you don't want to come off as the cheap lawyer, as the lawyer who is cheap. First, it affects your brand.
Oh, sorry. Sorry, I think we lost Colin again. Gabriel, can you confirm? Okay, as we confirm that, I'm going to ask the panelists to each of them give their parting shots. And I'll begin with last Martin. Martin, also, I want you to guide our listeners and attendees on the issue of responding to the bill of costs in Kenya, because I believe there's an option of filing submissions, which other jurisdictions also do have. Welcome, Senior Martin.
Yes, thank you. Thank you very much. Yes, I agree. In Kenya, the way to respond to the bill of costs is by filing submissions. Sometimes there could be documents that you wish to demonstrate to the registrar or the taxing officer that may not be readily seen. You can ask for leave to file this. But let me say it's been a pleasure to share insights on this judgment. As we have said, it has far ramifications. It has interpreted what has been the situation and expanded the role of discretion for taxing officers. We hope that it provides clarity and that it will also provide the opportunity for engagement as new interpretations come up. It is always good to review and interact on this, and I'm glad that the East African Law Society has provided such opportunity for lawyers to engage on this matter. Thank you. It's been a pleasure.
Welcome, Martin, and we are greatly indebted to your guidance and wisdom and dedication that you have put in to see that this is a successful discussion. I'll now proceed to Laston. Laston, I would like you to guide us on please emphasize and clarify more on how the bill is responded to, such that colleagues can benefit from that in Uganda. And then kindly give us your parting shots. Thank you.
Yes, thank you so much, Alan. Where a bill of costs is filed to determine what should be the compensation or the reimbursement of a successful party, that bill of costs is first subjected to a pre-taxation between the advocates or the parties. And then where you fail to agree on the items or any items you've not agreed upon, you make submissions, which then the taxation master or the taxing officer will exercise their discretion while following the laws to determine what to tax off or what to allow. That's really how you respond to a bill. But in terms of my parting shots, to avoid this sticky issue of the advocate-client bill, where a client who gave you instructions, you're having issues with the payment, not that you can eliminate them completely, but in terms of really billing as a lawyer, have clear billing processes, standardized billing policies in your practice, and then exercise wisdom to choose the right method of billing. I think Martin emphasized that when you're doing your engagement letter, you want to use the most effective method of billing for that particular work. Then, of course, communicate to clients and have expectations set ahead of time upfront, regular updates to clients so that they know actually you are committing to their work and they see the value that you're giving. Then when you're sending out the invoice, let it be a comprehensive invoice in terms of details, but it should be simple. Don't use jargons that are confusing. Sometimes the people paying our bills are accountants, and you have queries coming from accountants or whoever is supposed to fully pay off your bill. Utilize technology to track your billable hours, and then also you avail different modes of payment. Don't stick to one mode of payment. Avail different modes of payment, including electronic payments to ease payment for clients. And then in terms of ethical considerations, double billing. You think the client forgot what you sent earlier, you resend the bill again. That's one of the things that came to mind as a parting shot. Otherwise, thank you so much, Alan. You've been an excellent moderator. And thanks to our audience as well as the East African Law Society. It's been an absolute pleasure. Over to you, Alan. Thank you.
Welcome, Laston. Thank you very much for your dedication and good comments you've given on this call. I'll now call upon our last panelist, that is Wally, to give us his parting shots from Tanzania. Thank you.
Thank you very much, Alan. First of all, it is my pleasure to be here today. I think, again, I learned a lot and I was happy to share my experience from here and there. But what I would request actually would be that the East Africa Law Society perhaps look at how to harmonize the law societies to be able to take up this billings and sort of advocates with billings and remunerations a bit more seriously, and to see how we can standardize this practice so that, all of us are able to follow the law and be compliant. And even if we're using the law as a guidance, but there has to be a body that is governing us and is actually looking at what are the best practices. We all have to follow the best practices. What I've noticed is that we're not following the best practices, or most of us are not out there, and it's causing a bad image on Tanzanian lawyers, East African lawyers, and so on. So my plea would be that the ELS take up this challenge, see how to harmonize it, and hopefully work together. I would personally be willing to join in on any committee or movement that would lead to that harmonization. Thank you.
Thank you very much, Senior Wali. Gabriel, can you confirm if we have Colin back? Okay, as we wait for Gabriel to confirm that, I want to thank our panelists tonight for the wonderful deliberations and dedications, the time taken off, the wisdom shared, and the insights. We see that you had really gone ahead to immensely prepare for this webinar. Personally, my take home is that one, according to the decision of the Supreme Court of Kenya, we have the power of the judicial officer unfettered in taxing these bills. What the court did was just to render guidance. However, from the discussion and from the various jurisdictions, we have understood that it is important to standardize the billing practice of the law firm. Let us have clear communication to the clients such that they are aware of what our fees will be and for what we are billing them for. Then we can also learn that it is important to give value to the client other than building our experiences and having the challenges of being a young lawyer. Can we have a discussion on how to create this belief in clients that we are helping them and establishing that relationship, that we are doing them a service and we are offering value to the client. Then as a profession, let us avoid underbilling such that we do not have our services unfettered. From me, my name is Alan Msasile. I am a lawyer practicing in Imbara with Katembeko and Company Advocates. And for now, I'll call upon Gabriel to close this session by inviting all of us to join the East African Law Society for the AGM and conference that is happening in Uganda. Gabriel, you're welcome. Okay, I think Gabriel is out. We may not be able to get him, but for now, I will invite you to Uganda, where we are holding the East African Law Society Conference and Assembly. It is happening in November. Kindly join the East African Law Society. The dates that we have are 27th to the 30th. and it is happening at Speak Resort in Munyonyo. Kindly check the website and register to be part of us in Uganda. We look forward to seeing you there. Tubaniriza era tubalindiridde. For all my panelists and attendees from us and East African Law Society, it's a good night. Thank you.